Okay, hi everyone. Thanks very much for tuning in to our legal masterclass today on corporate finance. I'm Samantha. I'm one of the team members here at H Law, and today we're joined by Henry Humphreys and Annetta Beresford from Humphreys Law, and we're also joined by Fred Hutchison and Joshua Hayes from Hutch Law. And so before we begin, I thought I'd just like to ask each of our panel today to give a brief introduction about themselves. So perhaps Henry, we could start with you.
Sure, thanks, Sam. Hi, I'm Henry Humphreys. I'm managing partner of Humphreys Law. We're a UK firm focused on doing corporate finance and commercial type deals in the technology space. We're about 30 people, about 20 lawyers. We have offices in London and Bristol. Most of what we do is a very large relevance to technology deals, and most of what we do has some sort of international dimension. So sessions like this are very interesting because we often work with high quality overseas firms like Hutchison Law.
Hello, I'm Annette Beresford. I'm a partner at Humphreys Law as well. My main area is tax. I work on a lot of VC deals as well. We are in the team together here, and we're very pleased to be here today.
Good. I'm Fred Hutchison, a partner in Hutchison PLLC. We're a firm that focuses on transactions, financings, M&A for tech and life science, and more on ag tech related companies. We also represent investors. But the firm total team is 30 plus. We've got clients in about 35 of the 50 states in the U.S., but the focus is on the southeastern part of the U.S., south of Washington, D.C., and running down to Florida. We've got an office in Atlanta. We've got another office at Chapel Hill, where the University of North Carolina is located. We've had an office in Florida. We don't now. We have one non-lawyer consultant located where the University of Florida is located in Central Florida. Thanks. Glad to be here today. Josh?
Thanks, Fred. And thanks to the Humphreys Law team as well for helping put this together. My name is Josh Hayes. I'm a partner at Hutch Law. I'm a member of the corporate practice group, so I tend to work on a lot of financing transactions, equity financings, debt financings, as well as M&A for both our firm's tech and life science companies, as well as some of the ag tech companies that Fred mentioned. Looking forward to our discussion today. Thanks.
Well, thanks very much for that, and it's lovely to have all of you here today. We will shortly kick things off with a set of questions for the panel that we've prepared, and then we'll open up to the floor for further questions later on. So for everyone who's participating today, if you've got any questions throughout the session, just feel free to pop them into the chat at any time, and then towards the end of the session, we'll try to address as much of these as we can. So if everyone's ready, we can dive straight in. I thought we'd start off with a fairly hot topic that I think lots of us have seen on the front page of the news for quite some time now, and that's the collapse of the Silicon Valley Bank. Although there seems to be a bit of a less concern about the contagion spreading into the banking sector and wider economy, for now at least. Fred, perhaps we could first turn to you for some insights as to how the collapse may have affected your firm's practice or your clients.
Sure, thanks. Short term, there was a bit of a scramble as clients heard the rumors and quickly found ways to pull as much of their cash out as they could. We were providing advice. I mean, they were forced with a dilemma of, do they breach their bank loan covenants and pull that money out, or do they make sure they have money that they can reach and use in the future? But thank goodness the federal government stepped in and, in effect, made sure that funds in excess of the $250,000 per borrower, which is guaranteed by the FDIC, would also be available to everyone. So I think everything has worked out so far well. I think the real question will be the future. What will be the future of venture lending? I think Silicon Valley Bank was unique. They took a lot more risk than traditional banks. They had an interesting model, and they didn't do a lot of due diligence on people they lent money to, not like a venture capitalist or a PE firm would. They instead relied on who their investors were. And if they had confidence in their investors, then they really, in some ways, were indifferent to what the business model was. They were counting on them to, well, they would have invested already, but counting on them to step in the future to continue to invest and grow that company. To help them take that extra risk, they always asked for warrants. They wanted to make sure that you had all your banking relationship solely with them. It was a model based on, in some ways, the indifference of the CFOs. When the money was all in Silicon Valley Bank, they were probably paying a pretty low interest rate and doing very well, particularly after a $10, $30 million venture round, and all that sitting in a Silicon Valley Bank, and we know what kind of interest banks pay. I think we're seeing some private non-bank lenders at least sniffing around this area, people like Blackstone. They've been out there, but the interest rates have been much higher than what Silicon Valley Bank offered. But I think in the absence of Silicon Valley Bank and others that imitate it or follow its model, I think it probably will be some of these private non-bank lenders at much higher rates, and they probably are going to want warrants too. But we'll have to see how that plays out. The acquirer, First Citizens Bank, we know it's located here and has been very successful in acquiring these banks that have gone under and is well regarded by the FDIC. They're a very conservative bank. They are not a Silicon Valley Bank, and by any means. But if there's money to be made, someone will fill the gap, and we'll wait and see who that is. But right now, I would say it's very difficult to find good terms on new lending relationships. I mean, First Citizens and the Bridge Bank, it says they'll honor the existing banking relationships, but as to the future, we'll have to wait and see.
Mhm. Well, thanks for it. That was really interesting. And Henry, what do you think from the H law perspective? Has there been any sort of impact on the practice or the clients?
Yeah, really interesting thoughts there from Fred. Obviously, Silicon Valley Bank has had a presence here in the UK as well, although perhaps a newer entrance to the market than is the case in the US, where obviously it's been part of the VC scene for many years indeed. That said, I think it was still has been the largest provider of venture debt by volume in the UK. Much the same thoughts really. There was the weekend where the rumours started. I think something like $42 billion in cash was withdrawn from Silicon Valley Bank on the Thursday. I think that was in the US, which was something like a quarter of the overall balance sheet, quarter of the deposits. And then I think on Friday, Silicon Valley Bank UK was saying that it was solvent, had a separate balance sheet and would be fine. And by Sunday night, the government had stepped in and it had been acquired by HSBC for £1. So those of us that remember the 2008 banking crisis had our antennae up, shall we say, and it was quite a worrying or interesting weekend, depending on your perspective. But the good news, as you said in your question, Sam, is that there doesn't yet seem to have been a great deal of wider contagion into the banking sector, which is good news. I mean, there still might be, of course, but for now things seem to have calmed down, which is good. But I think really the collapse of SVB put a bookend on a period of real quietness for the markets that had started round about the autumn last year and have been getting quieter since. And I think with SVB going down has really changed the mood music quite a bit now, probably for the rest of this year, at least I would say. I think 2023 will be remembered as a very difficult year, certainly for anybody trying to raise venture capital, and certainly for anybody trying to sell their company right now, outside of probably a few exceptions and a few exceptional sectors. But that said, it's not all doom and gloom. VCs in particular tend to lay down their best vintages in times of crisis, when they get the best valuations and the most upside. And then PE for years has said that prices have been too high and they haven't been able to find enough assets at the right price. And then, of course, some areas of tech in particular carry on and doing very well. Obviously, AI is one of those right now, and there's just a huge number, an entire generation of generative AI apps and businesses that have been launched really seemingly over the last few months on the back of or related to ChatGPT and the other platforms that are out there. So there we go. And in terms of our clients, we had some that did have immediate worries about liquidity, some that did have some funds locked up in SVB, some that were concerned, but by the Monday it was sorted out. I think if you were banked with SVB and you had various facilities were there, you'd taken their venture debt and all your current accounts were there, and that would have been a very worrying weekend indeed. But it, as on both sides of the pond, it now does seem to have been sorted. So I'll put a full stop there, Sam, and come back to you.
Great, thanks, Henry. And just following on from that, then presumably you're now seeing some changes in the terms of the VC type investments that you work on. So what are the specific terms that you're perhaps seeing now in the post Silicon Valley Bank term sheets that you may not have really seen much in the last couple of years?
Well, I clearly we're seeing lower prices. The prices are going down. I think likely in the southeastern U.S., the prices historically have been more reasonable and not as frothy, I would say, as they are in California or Boston or New York. And so there's not quite the same level of adjustment that you might see in a Silicon Valley company as in a southeastern U.S. company. We're seeing certainly more due diligence by investors. We're not seeing some of the harsh terms that we've seen in prior downturns in the economy yet to see multiple liquidation preference where you get your money back times 2 or 3. Occasionally we'll see a full ratchet rather than a weighted average ratchet price protection. But usually if it's a full ratchet, it's only good for a year or 2 at most. The strong companies are still able to raise capital. You know, Henry mentioned AI companies. If you've got a strong AI company, they're probably still waiting on the doorstep, trying to get in that deal. The weaker companies are having to conserve cash, do some layoffs until they can either raise cash or figure out some alternative strategy, which may be M&A, where they get acquired again, not on the best terms. The venture capitalists and the PEs have historically done very, very well during financial downturns. And so they have historically gotten their best returns during this period of time. So we expect them to continue funding. They've got provisions in their limited partner agreements about the window in which they need to make investments. They can't sit on the money and just draw management fees. So we think we'll continue to see investments, but the terms will be different, particularly valuation. Board seats are always important to investors. If they can't control the company, they at least want the board to be one where a neutral industry expert makes the final decision on what's best for the company, not what's best for the founders or what's best for the investors, but what's in the best interest of the company. So it's an interesting time. We expect, we won't close the same number of transactions as we did last year, but I think it'll be a good number. It just, the terms will be different, particularly. I think they'll be slower to close. There'll be more negotiation on the price. And then I think there'll be more testing by the investors of the financial market. Is this one that really can grow and grow at a significant pace with the right amount of capital?
No, thanks, Fred. Oh, so sorry.
Go ahead. No, thank you, Sam.
I was just gonna throw the question back to Henry and to ask if you were envisaging perhaps the same sort of changes that Fred was talking about.
Yeah, very, very similar. Obviously, valuations, or the game of agreeing valuations has now radically changed for most companies, particularly those that are between funding rounds and now needing to raise the next funding round. As you've said, in some sectors, there's less pressure, shall we say, and some are still very hot, AI and so on, but across the board, it just seems to be a lot more pressure now on valuations. That then often leads to more bridge rounds, more convertible rounds that we might come on later on. Possibly the main thing that we're just seeing at the moment is that just deals are taking longer to progress, and sometimes it's hard to actually understand why that is, but very often it's because there's more due diligence being carried out by investors and buyers. They're just taking longer to get through that process. They're just generally more cautious about deploying capital. And again, just to a certain extent, sitting on their hands and waiting to see what happens over the next few months. But as Fred says here, if you're a good company with a strong management team, there's absolutely no reason why you shouldn't try and for a funding round anyway, start off looking for the typical terms you'd get in sunnier times, shall we say, the usual 1x non-participating convertible preference, the broad-based weighted average ratchet, pretty standard set of warranties, more friendly leaver provisions, a single investor board seat, and so on. For companies that are less in a position to be choosing which investors they take and when they take the money, they may find that they're under pressure on some of those terms. And at the extreme ends, yes, you're seeing more aggressively drafted liquidation preferences, more aggressively drafted warranties, more heavily structured deals, generally.
Well, thanks, Henry. And whilst we're on the topic of VC type investments, thought we could go back to basics a little bit. And Annetta, perhaps this one for you. Are there any sort of standard form documents for VC investments in the UK?
Yes, there are. They're the Venture Capital Association model documents. They get periodically updated. There's recently been an update for them to better suit US-style VC deals, which now has subscription agreements separate from the shareholders agreement. They are usually used as a starting point, especially for rounds such as Series A. For the smaller seed rounds, they're not always the best documents to start with. They can be a bit cumbersome and complicated, and it might be easier to go for a slightly more tailored set, which would suit a company in early stage better than that. But it is universally recognized, and it's a starting point in many transactions.
Thanks, Annetta. And so what about the position in the US, Joshua? Are the standard documents, do they have any sort of overlap or similarity with the ones that Annetta was talking about?
Yeah, I think so. It depends on if you're looking to do kind of a priced round or a convertible round. For the priced round, I think the gold standard is kind of the National Venture Capital Association, or NVCA, Series A forms. Those are templates that are put out by the NVCA. They update them from time to time. There's a lot of sort of optionality in those agreements. So some of the terms you're hearing, sort of full ratchet as opposed to broad-based weighted in ratchet. There's that type of optionality in those documents themselves. But as Annette mentioned, those can be a bit cumbersome for an early stage company. And so on the US side, there are these Series Seed templates that are kind of a short form version of the NVCA documents that we sometimes see as well. So that would be what we see for the price rounds or the equity rounds. For convertible rounds, we often see some version of a convertible note or a safe.
Thanks, Joshua. And yeah, it's interesting that both you and Annette mentioned terms like convertible rounds, price rounds, and convertible debt in more generally. So could you please maybe talk us through just at a high level of how these work?
Yeah, absolutely. So at a high level, a priced round, also called an equity financing, is where the company sells shares of its preferred stock at a fixed valuation. The discussion around valuation is one that happens between the company and usually an institutional investor like a VC. And the reason that's often an involved discussion that takes some time is because usually you have, on the one hand, the company who wants the highest valuation it can get, and is able to articulate a vision for why they should get that valuation. And on the other side, you have the VC, which is looking to get the best deal that they can get. And what they're bringing to the table is usually a lot of industry expertise, perhaps some sophisticated modeling, and a track record, right? Like, so they've usually been investing in this space for a while, so they've seen similar companies. And so they have that knowledge base that allows them to arrive at, where they're coming from the perspective of valuation. And then through those negotiations, those parties are able to arrive at a valuation and issue shares at that price. That said, for very early stage companies who may not be ready to have those talks with VCs, a convertible instrument like a note or a safe is often a good choice. Those are going to be a lot simpler as far as documentation. Take the 120 to 150 pages of the NVCA documents in a price round, and you can simplify that to 10 to 15 pages of documents for a note or a safe. There's often less diligence, and there's fewer variables for the parties to negotiate. And so it's easier to put a note in front of, say, your great uncle who you've known all growing up, who may be interested in investing, than the 150-page documents from the NVCA. And as far as convertible note rounds, sort of what they are, it's essentially a note or a debt instrument that can convert at a future time into equity. So when the company is ready to have that discussion with the VC around valuation, the notes can convert at that same class of equity that the VC purchases, usually at some type of discount. So the discount can either be some sort of percentage discount relative to the price that the cash purchasers are paying, or B, some sort of valuation cap discount. So in other words, if it's the upper limit of what the price would be. So if the company sets a $10 million valuation cap, then that's the highest price that the note shares will be issued at, even if, say, the company and the VC in the price round negotiate at a $15 million cap. And so those are some of the differences between the equity round and the convertible round. As far as standard terms, we still see kind of 6 to 8% on the notes, although that's creeping up with interest rates being higher over the last couple of years. 20% discount is kind of standard, although we have seen investors seek higher or more favorable discount terms as well.
Thanks so much, Josh. And presumably the position in principle in the UK as regards convertible loan notes and convertible debt, it could be fairly similar. But Henry, do you think you have anything to add as regards maybe the terms that you would see in a convertible loan note, like the UK's position on valuation caps or discounts? Do they have any sort of similarities or overlaps with the sort of levels that Josh was talking about?
Yeah, the one advantage with convertible loans, convertible notes, is that much of the terminology and many of the commercial points are the same as in the US that Josh has put forward there. The principal points to agree, as Josh says, is the interest rate, the maturity date, the discount, the cap, And then the circumstances of redemption, repayments, and conversion, various other things to agree. But as Josh says, less than on a price equity round. The means of execution, though, in the UK is very different from in the US. In the US, you have the SAFEs, which is an acronym, I think, for actually you'll need to tell me what the acronym is, but Safe Agreement for Future Equity, I think, or Standard Agreement for Future Equity, perhaps. I always forget, but the ubiquitous safes. But if you try and use a US safe in the UK, it won't quite work. So here you have two ways of doing it. You can either have a bilateral agreement between the issuing company and each investor, which you can call a convertible loan agreement, or you can call it whatever you want, but that's what it is. And it's a bilateral agreement signed by those two. Now, the difficulty with those is that if you only do one, well, that's fine, but quite often with convertible raises, you do a whole series with a whole bunch of different people, and you may not do them all at the same time. You may need to do them in a sequence with a few different closes, so as to allow you to get to the next funding round. And the difficulty is if you agree different terms with different convertible loan agreements, when you come to the funding round where they convert, you can find that the agreements conflict, or the mechanics produce unexpected consequences for some investors or the company. So it becomes a bit difficult. For that reason, some investors will insist on putting an MFN in, most favoured nation clause. And basically what that says is that if you do a deal with anyone else on terms that are more attractive than the deal that's being done with that investor, then the deal with that investor gets automatically updated to be on those more favourable terms, which is great for that investor, but then means that you've got to be really careful going forward with what other deals you do with other investors. As a hedge against all of that, and with an eye on simplicity, you can in the UK use what's called a convertible loan note instrument, which is a deed poll, which is a contract just executed by the company itself, and has all of the terms in it. And then in line with subscriptions by investors and receipt of the funds, they then get a certificate for their notes, which incorporates the terms of the convertible loan note instrument. And it is a very good way of ensuring that everybody's on the same terms, and also avoiding having to agree and negotiate a different agreement with each person. So those are the two classic ways of doing it in the UK. But otherwise, the terms are very similar in terms of what they are and what they do. The US is a larger market and classically has involved larger funding rounds. So you may find that on US deals, the triggers for automatic conversion might be slightly larger, perhaps, although the numbers that Josh has given there are very familiar to the numbers we often see on UK deals. Again, the discount might vary anywhere from between 10 and say 30%. 20% sounds about right to me. Sometimes in times of extreme pressure, generally people may agree higher discounts, and occasionally we would see that. But otherwise, yeah, very much sounds familiar. 12 to 36 months for a maturity date. It's about the same in the UK. And I'll put a full stop there. There's a different way of dealing with it in the UK, also with ASAs, but perhaps Anessa can talk to that point.
Yes, very briefly. ASA stands for Advanced Subscription Agreements. Economically, commercially, they're quite similar to a convertible loan note instrument in that the investor pays the money and doesn't get shares immediately, and it converts into shares at a later point in time. But it is different by its nature in that it is not a loan, it's an advanced subscription. So it's always meant to be an equity investment. It just is done at a time when the pricing is not yet available. This is purely for tax reasons. In the UK, we have a tax relief scheme for certain investors. It's called the Enterprise Investment Scheme. Individual investors can get income tax relief for certain investments, but you also have VCTs that are organized as EIS funds, so they they use similar concepts and also want to enable their own investors who are behind that to be able to claim that relief. To be able to claim that relief, it has to be a straight equity investment. It has to be for an issue of new shares, so it can't be a debt investment that then converts. So you have this slightly funny construct that you put the money in as an advance subscription without it being priced at the time. The downside is that it has to convert within 6 months. It's 6 month deadline. It used to be 12 months, but that changed, unfortunately. So the money has to be applied and pricing has to be done for it within 6 months. It's also, it has to be expressed to be non-refundable. So it is not a loan. It can't carry interest because it's not a loan. So it is just equity investment put in earlier, and then it converts. It can be a bit difficult when it converts within 6 months, but there's no funding round as an occasion for conversion. So we have to legislate in the document for the pricing if there is no round then, and it might not be very convenient. It's also if you have convertible notes on the one hand and ASAs on the other, to then potentially having invested on different tracks and dealing with that. So it can be done, but it can be a bit fiddly as well.
Thanks for that, Ned and Henry. Yeah, so Henry mentioned earlier something called safes, which sounds a bit more like a US concept. So maybe Fred and Josh, any one of you, could you tell us maybe just a little bit more about SAFE? Word on the street is that it was some sort of marketing concept that was coined Y Combinator or something. So is that right?
I don't know that for a fact, but it sounds true. So safes, I mean, generally there's been sort of a geographic divide. Typically safes were found for the early stage companies in California and on the West Coast. And on the eastern part of the U.S., they were generally convertible notes. The big difference, the convertible notes were debt, and they were shown as a debt on your balance sheet. They had a maturity date. They had an interest rate. The safes, and often there was a lot of, there wasn't one standard convertible note document, whereas in the safe, you can find various templates, but they're all pretty close to the same terms. The safe doesn't have a maturity date. It doesn't have an interest rate. It's not treated as debt of the company. And I think we're seeing a turn in the tide on that, and we're seeing more and more investors in the Southeast willing to accept safes rather than negotiating for convertible notes. So I think it does make it much easier to close the deal quickly. A lot of the investors in safes and in convertible notes are friends and family, or people that are not professional investors. I think with a safe, they've got confidence. They've got something that has market terms in it. They don't have to negotiate for it. Josh, further thoughts on safes versus convertible notes?
Yeah, no, I think that's right. Even in the Southeast, companies that maybe are raising a convertible round for the first time, I think are probably just as likely, if not a little more so, to use a safe. I think we do still see convertible notes, particularly if a company has used them historically. So its investor group is familiar with that form. A lot of times it's just easier to kind of carry that concept forward into future rounds. But yeah, to your point, Sam, about it being a marketing effort. I mean, they did kind of put it in the name, right? Like safe, for what tends to be kind of a risky, very early stage investment. And then also, since it stands for simple agreement for future equity, there's that simplicity element in there too. So they're sort of trying to convey that it's both safe and simple. And I think that probably did help with some of its initial adoption.
Thanks, Josh and Fred. So now perhaps moving straight up into venture debt. It's something I've read about that seems to be, quite a popular thing these days. So, but what exactly is venture debt, and are you seeing a lot of it Henry, perhaps you could start us off.
Yeah, sure. Although I just preface this by saying I'm an M&A and VC lawyer rather than a straight debt lawyer, but we have a team here that advises on venture debt deals. And in fact, we're doing 2 or 3 of them at the moment. They can be quite large transactions, actually. One of them is 50 mil UK sterling. It's an interesting thing. Venture debt can mean different things in different concepts. It's not a legal term. There's a range of different sorts of ways of doing it. But in simple terms, from a founder's perspective, particularly once you've done a few funding rounds and been diluted, you then quite often have a choice between looking to execute the next funding round and be diluted even more. And if it's at a massive uptick in valuation, then that may be okay because the dilution may be very limited. But if it's not at a massive uptick, then the dilution may be fairly punitive, and yet the eventual exit and liquidity that will come from the value of your own shareholding may be a long way away. And so classically, looking then at a straight debt raise as either a bridge to get through to the next round or as a means of acquiring other companies can then become quite attractive. Obviously, the company has to pay the interest on the debt, and there's a lot of things that come with it, but it shouldn't then affect the dilution of the founder shareholding. So often it's looked at in that context. From what we see in the UK, there's quite a wide range of venture debt lenders. SVB were one of them. I think continue to be owned now by HSBC. There's a bunch of different funds that, should we say, have come from more of the old school world of banking and corporate finance, and then there's a bunch of newer funds that, should we say, haven't. There's also quite a few overseas funds that will come and do venture debt deals in the UK. We're acting for a Canadian fund at the moment, investing into a insurance tech business in London. One thing venture debt providers ask for is warrants. Not all venture debt providers ask for warrants. Some don't. But it does seem to be a common theme of venture debt deals. Warrants are basically options. A warrant really is another word for an option. Classically, a warrant will come with it more in the way of equity-like rights than perhaps an option would. And then the structure of the warrants seem to vary deal to deal. In their most simple form, they'll just be over a fixed set number of shares and work in a very similar way to a standard option. On other deals, they can be much more exotic and have ratchets built in terms of the returns they generate at exit. Those sorts of arrangements can become very complicated. We've even seen one lender actually looking to take growth shares rather than warrants or options up front. Obviously, come with a security package, which means that the money will be lent into the venture, and then the lender will take security over the assets of the lender itself. So sometimes that then means that the borrower's group will have to be restructured so as to put in a holding company above the existing operational company. And the reason for that is so that the lender can then take security over the shares in OpCo, rather than having to take security over the shares held by the shareholders individually. So sometimes we see those. Again, that can make it more complicated, and you end up having to do a share-for-share exchange transaction to make that happen. We're doing one of those right at the moment. And there we go. So I suppose in summary, it seems to be an evolving area in UK corporate finance. There's not masses out there in the way of established market practice. Most of the deals seem to involve companies that are at nearly break-even points or approaching profitability, or they're being lent into companies that are going on to acquire other businesses. SVB, as I say, were the largest lender out there, and we remain to see what happens now that they're owned by one of the big banks.
Thanks very much, Henry. And Fred, perhaps you could share with us if venture debt sort of carries the same sort of meaning in the US and if there are any sort of different market practices to what Henry's described.
Sure, happy to. Yeah, it generally means the same thing. It's we've got companies that have matured, they like to avoid further dilution, and then they turn to venture debt, even though it may, like in the UK, involve the issuance of a warrant or a right to buy shares of the company at a set price in the future. That's still less dilution than going out and raising a full round of venture capital. So we're it's open. I don't know what we'll see in the future. There's a big hole created by the absence of Silicon Valley Bank and their support for emerging tech and life science companies. They do, our early clients, they might bank with Silicon Valley Bank, but they're not borrowing money. I mean, they've got a payroll account and they've got a checking account, they can pay bills, and they love to say, yeah, we bank with Silicon Valley Bank, but it's only later when they've got a predictable stream of revenue and have got professional venture investors that Silicon Valley Bank or future venture debt lenders will really look seriously at them. They do require security on all the assets of the company. You might be able to negotiate a provision that says, we're not going to pledge our intellectual property to you, but we'll pledge to you or commit that we won't pledge it to anyone else or give anyone else a lien on our intellectual property. I think that's, Josh, further thoughts on venture debt? As I said earlier, I think we're going to see some private non-bank lenders enter the market, but the pricing on that and the terms on that will be not as friendly as we've seen in the past from Silicon Valley Bank, but that may be all there is. And if that's the case, our clients will take it and live to fight another day. Josh?
No, I think you've covered the field pretty well on that, Fred.
All right.
Oh, thanks very much, Fred. So now I guess stepping away from VC a little bit and into M&A. So we've heard about things like distressed sales and fire sales and so on. So in light of what's been discussed today, Annetta, do you think you will see the terms of these sorts of deals changing anytime soon?
Well, yes, it's always slightly different when the context is a distressed sale where there is a need to sell, and it of course affects the negotiating position of the parties. It might be harder for sellers to get a good deal. Warranties, indemnities are negotiated hard with little leeway for the sellers. There's always a question who gives warranties and indemnities in the first place. We often see VC investors or private equity investors say, well, we haven't been involved in the management of the company, we won't give any warranties, and then looking at the management to give warranties. That's often not palatable for the management either, so you might then be looking for warranty and indemnity insurance, which has its own problems. There's always the question of what is covered, what's not covered. If there is a will and a common intention between the parties, they'll usually get a sale done, but it can take a while, and there's always a risk that either the buyer can't raise the funds necessary to complete, or the target might even run out of cash before the completion happens. There can also be issues when previously ES investors have subscribed for shares, maybe even ES funds, as for those investors, it can actually be more profitable to let the whole thing go bust and then get tax relief, loss relief, which they then can set off against their income tax, than having a sale on terms that are not quite favorable enough to them. So you can end up in a situation where different shareholders have conflicting interests, which can also be a hindrance to getting a sale done. I expect it's probably similar issues in the US.
Fred or Josh, do you have anything to add on the US position?
No, I mean, we do run into that issue with different interests depending on the shareholders and their particular rights. We sometimes see the venture capitalists try to merge the company into one of their other portfolio companies, so they don't have to take a write down on the valuation of that particular investment. But that's fraught with all sorts of issues, and luckily we don't see it often. Usually, can't say the bad motives, but usually it's purely in the interest of the investors and rarely in the interest of the shareholders overall on those types of situations. Josh?
Yeah, I think as Annette said, we are seeing sort of an increase in lower offers from buyers, and part of that could be a function of that distress sale, where companies, it may not be the ideal time for them to sell, but they feel like they need to because they're running out of cash runway and are unable to raise subsequent rounds of financing. For those deals in particular, but I think also more broadly across the market, we are seeing larger parts of the consideration being pushed to post-closing earnouts, which are parts of the deal that are contingent on the company post-closing achieving certain metrics, so usually certain revenue or profit targets. And I think the challenge that we see on the sell side is that once the seller sells its company to the buyer really has control over a lot of the marketing, sales efforts, as well as kind of that back office, financial accounting and tracking of revenues and profits. And so we do often see disputes arise post-closing around these earnouts. And one of the things I think we'd expect to see would be an increase in those disputes as a larger portion of the total deal consideration is sort of vested in those post-closing earnouts. We do sometimes see reps and warranties insurance. So that's a third-party insurer coming in saying that they'll stand behind the seller on some reps and warranties. That can sometimes result in some easier sledding on the negotiation around those reps and warranties as between the buyer and seller. But you do sort of get another set of negotiations, particularly on the buy side, around what's covered, what's not covered, and how to fill in any gaps in coverage. So those are some things that we've seen, I would say, recently.
One of the things I would say is, we push our clients, and most of the time our clients are selling, to negotiate, take your time, and let's get a detailed letter of intent that spells out all the key terms. A lot of them want to rush into it and say, all right, we got the price. We've got a no shop here. They're going to do due diligence. We've got an earn out. Let's move with it. And yet they don't address the key issues like caps on liability, the survival period for the reps and warranties, which reps and warranties they apply to. So how much is going to be in escrow? How long is the escrow? Is there an escrow or is there a holdback, which we hate? And so, we often tell a client, look, there may be 10 to 20 different drafts for this LOI. Let's not rush into it, because once you sign that, your bargaining power goes to almost zero. You're not going to win any legitimate open issues going forward if you want to stick with this deal. So that's really key for our smaller clients that are being bought. It's usually for cash. We don't have many deals that have a financing contingency. It's usually for cash, and it's usually a strategic buyer that's dealt with our client in the past. They've got a gap in their technology, and the selling company can fill that gap, particularly with a well-qualified group of employees, software engineers, scientists, whatever.
Thanks very much, Fred and Josh. Seeing that we've just under 10 minutes left, I thought we could briefly talk about some cross-border investments. For example, we've seen more and more UK-based funds and companies that are looking to make an investment into the US under US law. So Josh, maybe you could just summarize like the key key bits of information you would tell a UK buyer. Presumably, it won't be just to take, like a US share purchase agreement and then change the governing law clause.
Right. We do see that from time to time, and we are usually successful in swaying them away from that approach, because I was actually just taking a look at the BVCA forms for venture debt, and they are quite different, and not just kind of the chapter and verse of the statutory sites, but different enough to where I think if a company is interested in investing in the U.S., it makes sense to start with U.S. documents. Certainly, that's what we would be most familiar with. That's what the other side's going to be most familiar with, and that's probably what's going to make it most efficient for everybody. If a UK company insists on using sort of UK forms, we can work with that. But I can tell you what you're probably going to end up with is something that looks very similar to a US form. To your question around, what's kind of the process for doing business in the US? Oftentimes, what we'd recommend is that a UK company start with a wholly owned Delaware subsidiary. Why do we use Delaware? It's a tiny state here in the US, but it is one that has one of the largest and most well-established bodies of corporate law. It's very predictable, it's very business friendly, and so most practitioners in the US are going to be familiar with the law of their home state, in the case of me and Fred, North Carolina, as well as Delaware, and that's sort of true wherever you go across the country. And so we would recommend starting usually a Delaware holding company. Any investment would go into that Delaware holdco. And again, that's just sort of because that's what the US investors are going to be most familiar with. Fred, anything to add on that?
No, and I would tell them pay particular attention to the financial side. GAAP US may be very different from the what they're used to in the UK. Make sure we've got a clear understanding of what those numbers mean and any differences in sort of accounting, like revenue recognition procedures.
Perfect. Thanks very much. And Henry and Annette, what if it was the other way around, with a US investor coming into the UK, what would you say to a buyer like that?
We probably see it more than Fred and Josh, because historically, classically, we'd be more buying of UK companies by US investors than vice versa. It used to be the case that pretty regularly, and Annette and I used to work for a big American firm some years ago now, and whilst there we would do a lot of buy-side work acting for US investors. And it used to be the case that on almost every one of them, some attempts would be made at the beginning to try and use a US-style SPA and US language documentation and everything else, and then apply it to the UK. And invariably, we would then have a somewhat fraught discussion with clients to try and explain why this was a bad idea. Sometimes we would win those points, sometimes we wouldn't. Inevitably, invariably, it is not a good idea. Different systems of laws, different legal documents. Many of the commercial terms mean the same thing commercially. How they're actually dealt with in the language is completely different. We have a term here of a square peg into a round hole, and taking a US SPA and using it in the UK is very much one of those. And if you want to keep things efficient, lean, quick, try and minimize legal costs, and do things fast and efficiently generally, then that's not a good way to do it. These days, though, you see that a lot less, actually. I think US buyers are now much more familiar with transacting in the UK generally, and more receptive, perhaps, to using local counsel and progressing using local documents. Would you agree with that, Annette?
Yes, from what we see, definitely. And it's a good thing also, since as Henry says, the whole concepts are quite different. I work on tax a lot. That's also different how that's dealt with in US style SPAs and in the UK. I think in the US you tend to have warranties given on indemnity basis. In the UK you usually have something which is called a tax covenant, which is a more general thing that's meant to draw a line in the sand and essentially make the sellers liable for tax liabilities that result from events before completion, and the buyer takes liabilities that derive from events after completion. And it's a whole general different concepts. A covenant to pay is different from an indemnity. It's meant to be a pound-for-pound recovery. It's not subject to mitigation. It's not subject to showing particular loss. It's just saying you have a tax liability of a certain amount and then a certain part pays it. So when you then mix up different types of SPAs, it's not that easy always to marry up those concepts. But as Henry says, we've been in the position and we've had to square it more than once.